Okay, so today the topic is High Court. Now, High Court, yesterday we discussed about subordinate courts and tribunals. So the institution of High Court is at present, since from 2019 there are 25 high courts in a country. Okay, and the articles which deals with high courts are 214 to 231, which is imbibed in part 6th of the constitution. It deals, and what is the role of high courts? So it deals with the organization, independence, jurisdiction, powers, procedures, and there are so many things. So it deals all of those things. Now, composition. If we talk about the composition, so in every high court, whether exclusive or common, there is one chief justice and other judges. That's it. And president may from time to time, president as he deems fit, they specify the number of judges or the strength of high court. So constitution does not specify any strength for high court, but it has not given any strength to high court judges. So in this regard, president has the option that he may or she may from time to time, as he deems fit, they necessarily appoint persons as judges. So president determines the strength of high court. Just remember this, it's very important. And how the judges are appointed? So appointment process involves, president appoints the judges, but in consultation, but he has to consult to Chief Justice of India. If president is appointing Chief Justice of High Court, then he has to consult Chief Justice of India plus governor of that state. So president shall have to consult with the governor of that state which is concerned with the election of the Chief Justice of High Court along with Chief Justice of India. Now, for the appointment of other judges of High Court, appointed by the president, but consultation, whose consultation? This time the consultation will be given by the Chief Justice of concerned High Court, in which the judge has to be elected. He has to be consulted. He has also need to be consulted along with the Chief Justice. So for appointment of other judges, the Chief Justice of concerned High Court is also be consulted. So along with Chief Justice of India, Governor of that state, plus Chief Justice of concerned High Court. Now there is a case famously called as second judge's case. The second judge's case, which is happened in 1993. Here Supreme Court ruled that no appointment of judge of High Court be made unless it is not in conformity with Chief Justice of India. So it's talk about the conformity. That means Chief Justice of India should have to concern or give their conformity that yes, you are like go ahead and appoint the judges. Then there came the third judges case in 1998, where Supreme Court opined that in case of appointment of High Court judges, Chief Justice of India should be consulted, but Chief Justice should consult, in the case is Chief Justice should consult collegium. Okay, collegium. And in collegium at that point of time there were two senior most judges. There were only two senior most judges, and those judges are need to be consulted while electing the judge of a high court. So there is a sole opinion of a Chief Justice of India alone does not constitute consultation process. That means only the whims and fancies of Chief Justice of India is not applicable. They have to concern with the two senior most judges as well. Then there came the 99th Constitutional Amendment Act of 2014, where NJAC, National Judicial Appointments Commission, was framed to replace the collegium system. But what happened? Supreme Court struck down this 99th Constitutional Amendment Act as it is unconstitutional. It's finalized, and this verdict, in which the NJAC had been declared as null and void, unconstitutional, was the case referred to as fourth judge's case, and this case is in 2015. Now in this second part we will talk about the qualifications of being a judge of a high court. So for being a judge of a high court, a person should be, the first and foremost qualification is that he or she should be a citizen of India. Next, second qualification, he should have held a judicial office in territory of India at least for 10 years, or have been an advocate of high court, of any high court in succession for 10 years. It's not like he was a advocate in high court for 2 years, then nothing, then again for 2 years. No, in succession he has to be an advocate for 10 years. Okay, so from the above qualification it is clear that there is no a sort of kind of minimum age prescription or such things is there, but it is clear that Constitution has not prescribed any minimum age for appointment as a judge of a high court. Unlike this is in the case of Supreme Court, there is a thing of such thing or provisions. So the Constitution makes no provision for the appointment of distinguished jurist as a judge of a high court, which is in case of Supreme Court, where he has to be a distinguished jurist in the eyes of a president, but not here. Next, oath and affirmation. So what about the oath and affirmations? So person who is appointed as the judge of a high court, so before entering his office he has to take oath or affirmation. Oath is for the believer of a god and affirmation is for those who do not believe on God. Okay, so what kind of oath? Like to be a true faith and allegiance to the Constitution, uphold the sovereignty and integrity of the Constitution, to duly and faithfully discharge all my duties with the best of my knowledge and ability, and to uphold the Constitution and the laws at any circumstances. And what about the salaries and their allowances? So if we talk about the salaries or allowances or privileges or leaves, these all are determined by the Parliament. So these all are determined by the Parliament will decide what kind of salary they will get. But their salaries cannot be varied to their disadvantage after their appointment. Okay, so in 2018 the salary was something, but it cannot be varied to their disadvantage, that now we won't give you the amount of salary, so this can't be happen. Okay, and there is also a provision of pension. So whosoever is the retired judge or a chief justice, he or she is entitled to get 50% of its last salary, whatever last salary he got before retirement. Then apart from that, 50% is to be granted as a pension to him or her.